Thank you very much, Massimo, and thank you to all the previous speakers. Indeed, first, I would like to thank from the deep of my heart, Mr. Encu for sharing with us. I understand this is difficult, and therefore I really would like to share my sympathy and express all my solidarity in the face of such horrific events and such a difficult struggle. And similarly, I would like to express my admiration and solidarity to Mr. Altiparmak, because struggling on a case like this is not an easy task, as he eloquently shared with us. And of course, I would like to share Massimo and ICJ in general, not only for inviting me, but for organizing this event. Because I do think, and I fully agree with Mr. Altiparmak, impunity begins or is very much helped by silence. If we allow indifference on these kind of events, we are somehow enabling impunity and making the struggle for justice further complicated. So keeping up or speaking of these events, making this known and creating the opportunity for sharing on these kind of events and maybe experiences or lessons learned also from other places is extremely important and is also a way that contributes and goes in the direction of what was expressed before: never again. If we do not remember what happened, if we do not speak about what happened, this might happen again and again. So I really would like to congratulate on this initiative. Unfortunately, Roboski may be a textbook case for what impunity is about. I have to be honest, listening to you, I could tick the box on all the tools for guaranteeing impunity. And this is also important to share. The good news in the face of so many bad news is that international law, as Roisin already somehow shared, offers some answers to all these obstacles. When it comes to impunity in particular, because Roisin shared with us what should have been done. Although we are in counter-terrorism, there are certain standards that we should abide by. But after it happens, what are the obligations of the state? What has to be done to address this? And I think a text that if we take literally, we can tick the box, are the updated principles for the protection and promotion of human rights through action to combat impunity. And I think that particular instrument is so very relevant in this case, because it also answers what Mr. Altiparmak evidenced. The fact that sometimes legal rules, procedural tricks, procedural rules are used to favor impunity. And that instrument gives us some answers and some standards we should abide by to actually avoid this kind of abuse of the law and abuse of the rules. I would really want to take 1 minute to go back and to read what the definition of impunity is in those principles. Because if we read that definition, we understand how the case of Roboski Massacre is literally the image of what impunity is about. Impunity means the impossibility, de jure or de facto, of bringing the perpetrators of violations to account, whether in criminal, civil, administrative, or disciplinary proceedings. And here we've heard that we have them all, on top parliamentary as well. Since they are not subject to an inquiry that might lead them to being accused, arrested, tried, and if found guilty, sentenced to appropriate penalties, and to making reparations to their victims. And I would underline also this part. It's not a coincidence that it says making reparations and not paying compensation. Reparations, when it comes to this kind of gross human rights violation, is much more than money. As Mr. Encu explained so eloquently, providing pure compensation is actually re-traumatizing in the face of this kind of events. It's perceived as bloody money. It's perceived as something that is not encompassing the gravity of the harm at stake. And here, I would say that both elements of what impunity is made about, lack of justice in terms of bringing to account those responsible, and lack of reparations in this integral sense of the word, are unfortunately met. If we read those principles, they also spell out what would actually be the obligations of the states in the face of this kind of gross human rights violations. And indeed, there is a reference to investigation, and not whatever kind of investigation that meets certain standards. And from what we've learned and what we've heard, I would say that here it's difficult to see them complying those standards, neither were investigations prompt or thorough. With regard to independence, I'll come back to this in a minute, let aside impartial. Take measures to hold accountable those involved. As we've heard, apparently there is no single person who has been prosecuted, apart from the victims or the lawyers, who has been prosecuted or held accountable for these events. Providing reparation in this integral sense, and upholding the inalienable right to know the truth. And I would say this is important because on this massacre, we know the events, unfortunately, but the truth is much more than that. Is really knowing who was there, who has done this, where the order came from. And I would like to emphasize that this right is so important because it is not only individual, if we please, it is not only with the relatives themselves who have been hit by this huge tragedy, but it is with society at large. The society in Turkey, but society, I would say, globally. It is unacceptable in the face of this kind of events that we don't know 10 years later what has happened, the circumstances in the progress of the investigations. And I would like to emphasize that all these obligations are instrumental and crucial to actually prevent reoccurrence. Because when we discuss about struggling against impunity, there is often what I see as a misconception that is very much about looking into the past and addressing the past. And indeed it is, but it is crucial to actually look also to the future. If we don't look into the past and we don't address the past, this may happen again. And in fact, this is part of general obligation that is also preventing reoccurrence. If we read those principles, and we don't have time, but I really would invite you to compare the facts that we listen to the principles in there, and you will see that it's literally a tick the box exercise. We would find that, for instance, there are certain rules that states should abide by when it comes to superior responsibility. Principle 29 here, it's grossly violated because there are certain restrictions on military jurisdictions. So of course, when we are facing alleged gross human rights violations, it's ordinary courts that should be competent and not the military jurisdiction and military tribunal because of lack of independence and impartiality. All the procedural rules and the use or abuse of those procedural rules, we do find them somehow jeopardized by what we've heard here. There is an additional instrument in international law, again, soft law, but nonetheless somehow crystallizing customary rules, which seems to me to have been violated as well. That is the Minnesota Protocol on effective prevention and investigation of potentially unlawful death. In its latest revised version of 2016, I would actually say that when we listen to the fact that there has not been any investigation or crime scene investigation, witnesses have not been heard, they have not been allowed to have access to files of the investigation or to actually actively participate and contribute to the investigation. All those aspects that might seem procedural are actually crucial to ensuring the proper respect of these international standards. One thing I would like to mention here is that indeed there is also relevant case law. As Roisin mentioned earlier, there is a lot also from the European Court of Human Rights, which unfortunately in this case doesn't seem to have been the most open and progressive partner in the struggle for justice, which is unfortunate because in the past there have been relevant judgments, and I think in particular of one delivered in 2013 against Turkey, and I apologize for the pronunciation, the case Benzer and others against Turkey, which resonates very much with this case, 34 victims, aerial bombings of 2 villages. In that case, it must be said, the European Court of Human Rights found violations both for the kind of operations carried out, but also for the lack of proper investigation, prosecution, and reparation to victims. It is unfortunate, therefore, that in this case, they somehow departed from these precedents. But that's why I would like to share with you something that might sound far away, but unfortunately, I do think is closer than we might think. Today, while we speak precisely, the 13th of December is another anniversary. It's 23 years, precisely 23 years, where in another continent, a massacre very similar, it will resonate with you, was committed. I'm speaking about a massacre committed in Colombia, in a village called Santo Domingo. So on the 13th of December, 1998, in Santo Domingo, precisely in a situation very similar to what you have been telling us, the Colombian army bombarded the village. And this resulted in the death of 17 people, including 6 children, and in 27 wounded people, including 10 children. For several years, Colombia blamed this attack on the guerrilla, on the terrorists, on the FARC. But eventually it turned out that it had been the Colombian army all the way. Of course, also the kind of proceedings that the family, the survivors tried to bring about had to go through a number of incredible obstacles, legal obstacles, procedural obstacles, threats, reprisals. Why am I telling you this story? Because I think that sometimes listening to what I could consider in this case a lesson learned might also encourage and inspire you in continuing this very important struggle for justice. That case, Santo Domingo, eventually was brought to the Inter-American Court of Human Rights, which is the peer of the European Court of Human Rights. In 2012, the Inter-American Court of Human Rights issued its judgment, which is called Massacre de Santo Domingo against Colombia. And in case you're interested, it exists also in the English version, which I truly recommend you to read because I think it's a very comprehensive reading of this kind of situations and the obligations a state should abide by to actually comply with its international human rights obligations. In that case, the court made some very important findings. The court found a violation of the right to life, of course, on what the European Court of Human Rights would see as the substantive nature, sorry, of the right to life, but also the procedural one. And they considered that this was an aggravated kind of violation, in particular vis-a-vis the children that were involved. Why is this important? important because also in the case of Roboski, there were several children. And when we do have children involved, states would have and had an obligation to protect those involved compared to adults. The court, the Inter-American Court, in that case also found a violation of the prohibition of torture and inhuman and degrading treatment. And this is interesting because they found it violated for those who were injured during the massacre but survived, but also for the relatives, because they found that living with such a sorrow, having to go through all those obstacles, also being blamed for what happened, was an attack on their dignity, amounting at the very least to inhuman and degrading treatment. But the court also found a violation of the right to property, because of course an aerial bombing also destroyed the properties of those who were there. This might sound trivial, but these people were left without their living sources. On top, there was a violation of the freedom of movement because people were later on forced to displace. And there was also a violation of the right to privacy and dignity. And I think this is very important. Finding that kind of violation recognizes an aspect that might not be that evident in this kind of cases, but it's at the core of what human rights are about. We've just celebrated the Human Rights Day. Human rights are about dignity. And these kind of events and the lack of justice actually revolve around denying the dignity of some in the face of the abuse of others. What I found interesting is that the court ordered a number of measures of reparation, well beyond pecuniary compensation. The first one being ordering Colombia to actually hold a public ceremony where they acknowledge the international responsibility and they beg pardon to victims. The European Court of Human Rights doesn't even dream about this, but there are other international human rights bodies that do recognize this important aspect of reparation. For instance, the Human Rights Committee is opening up to this kind of other measures of reparation, which might sound folklore to some, but in my view, are actually at the core of recognizing the kind of violation that has been perpetrated. Of course, the Inter-American Court of Human Rights also ordered Colombia to provide medical and psychological support to all the survivors, which sounds, again, maybe not so much, but recognizes the kind of traumatization and the long-lasting impact that these kind of events have, not only on survivors, but on the whole community. And as we've heard, and I was very moved when Mr. Encu said this, a village that used to be a joyful place was turned into a place where they do not celebrate anymore. In my view, the very right to celebrate and the very right to continue dreaming, those dreams that were shattered should be recognized and be at the core of any kind of future struggle for justice. I'm about to conclude. What I would like to say is that also at the universal level, so UN, we do have relevant standards that we could refer to. Roisin already mentioned the General Comment number 36 of the Human Rights Committee on the right to life. So with an interpretation that goes very much in the direction of what I've said, not only certain negative obligations, but also several procedural positive obligations. But also we do have a number of views or decisions of the Human Rights Committee, although I have to say the Human Rights Committee has not to this very day pronounced itself on a case of a magnitude that can be compared to this massacre. So I would like to end on a, if not positive, realistic, but proactive note. That is, we do have the tools at the international level to try to struggle against these kind of injustices. And from what I've heard, there is the will to continue this struggle. And I think this is key, precisely to write a different page for the future. I have to say that, in my view, nothing predicts future behaviors as much as past impunity. And we do have to try to change that. And I think this is our collective responsibility, and the very fact that we are here today together is our guarantee to try to write a different page for the future. Thank you very much.